Let's talk about this right now with my guest, law and crime trial analyst Cheyanne Rossi and criminal defense attorney Matthew Mangino. Gentlemen, welcome. I'll start with you, Cheyanne. Are you surprised by this?
No, this happens probably 90% of the time in criminal cases. And for your viewers, a preliminary hearing is a very low hurdle for the prosecution. I think in my 27 years, only one prosecutor has failed at a preliminary hearing. And that's because the burden of proof is probable cause, which is about 40% certainty. And it's extremely common and pretty wise on the part of the defendant to waive, because if the government puts on a case, it could taint any potential jury pool.
And Matthew, my question to you is, now that that's done, and we heard an arraignment has been listed as the next date, what goes on? What's the next step? I mean, is this give a sense to you of where the defense will ultimately go? I mean, do you have the feeling that perhaps they will plead guilty to these charges? I'm curious your thoughts.
Well, it's really hard to make some prediction about that at this point. And Jesse, I agree with Cheyanne that it's very rare that you have a preliminary hearing, and certainly the news that could spin off of that could have some prejudice with regard to selecting a jury. But as a defense attorney, pinning down some witnesses under oath with regard to their testimony at a preliminary hearing. The next thing that's going to happen is there's going to be, once the information has been filed as it is here, there'll be discovery and the ability to obtain information from the prosecution with regard to the evidence that they have in this case. And then ultimately it sets a standard for any pretrial motions that you might want to file with regard to this case as well.
And just to give our viewers a sense of what was happening in that courtroom, we got word that there seemed to be a lot of people on Jamie Kloss's side of that courtroom and only a few people on Jake Patterson's side. Of course, once we have an update more about this case, we'll make sure to let you know. But just a remarkable story about a 13-year-old girl who was found alive, but a horrible existence, and what she went through is something that can't be denied. Right now, let's talk about Cheyanne Harris. The prosecution and the defense have just concluded their closing arguments, and now it will be in the hands of the jury to determine whether or not the mother of 4-month-old baby Sterling will be found guilty of murder and child endangerment. You might remember that he was found dead in his swing seat, died from a combination of malnutrition, dehydration, and an infection from a diaper rash. In other words, he was left to die. That's the prosecution's argument. The defense has said that a combination of depression and substance abuse, in particular meth, needs to be considered by the jury because the defendant could not form the required intent necessary in order to be found guilty of murder, that she didn't intend to deprive her child of critical care. If anything, this was negligence. Now, let's begin with the prosecution's closing argument from earlier today, in case you haven't seen it. Take a look.
On May 1st, 2017, the defendant was given a blessing, a baby boy, a healthy, happy, innocent baby boy. Now that you have heard all of the evidence, it should be clear to you that the defendant didn't want the responsibility of that blessing, that she didn't accept the responsibility of that blessing, and that she let her blessing die a slow and painful and unnecessary death. And just as during Sterling's life, when the defendant took no responsibility for him, it's the same in his death. That's why we're here, because she doesn't take responsibility for his death. Actions and consequences, that's what this is about. You, as the jury, will soon be in the position to decide what her actions were and what are the consequences. Is it guilty? Is it not guilty? At this time, I'm going to go through some of the evidence with you. This is my chance, the state's chance, to walk through the evidence, to apply the law that you've just heard from the judge, and to make arguments about our case. and as to what makes sense, as to what's reasonable. You're going to hear that word a lot this morning, reasonable. The state has to prove this case beyond a reasonable doubt. It is our burden. We gladly take it on in every case, but remember what the definition for it is. If after a full and fair consideration of all of the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. Firmly convinced. It does not mean beyond all doubt. It does not mean beyond any doubt. It does not mean beyond a shadow of a doubt. Don't hold the state to a higher standard that we do not have to meet. Are you firmly convinced? What's reasonable?
Okay, so that was some of the prosecution's closing argument from today. Gene, something to consider here is this idea of general versus specific intent. And
yes,
we understand that the jury will only be instructed on general intent. Can you explain that, how it relates in this case to the charges of murder and child endangerment?
I guess I'm not familiar with Iowa law. I am actually shocked that in a premeditated murder case or a second-degree murder case, they don't have an instruction on specific intent. Here's the difference. If you have a general intent crime, then intoxication, being high on drugs, that does not negate intent. That's why when you sell drugs federally, at the federal level, if you're drunk or intoxicated when you sell a kilo of cocaine, that general intent does not prevent you from being convicted. Specific intent, which is a high level, premeditation is specific intent. Intoxication can negate specific intent. There was a famous case in UVA a few years ago where a boyfriend drank a case of beer and threw his ex-girlfriend against the wall. He was charged with premeditated specific intent murder. The jury dropped it to voluntary or involuntary manslaughter because that's more general intent. That's the difference. It could decide a conviction or acquittal.
Now, here, Matthew, the idea here would be that, and the prosecution saying this, that she didn't intend for Sterling to die, but she deliberately withheld critical care. She knew what she was doing. She intended to endanger him, that she intended to not provide him what he needed to survive. And the idea here, and we've seen this before, can you ever have that level of neglect and not intend it? In the sense, yes, we're talking about intoxication and postpartum depression, but really, isn't that a tough thing to show?
Well, it is. I mean, but you know, we're dealing with an individual who we've heard testimony that she had some mental health issues. She was addicted to meth. You know, her negligence at a minimum was gross negligence. The issue is, did she intend to cause this ultimate harm that occurred here? Now, certainly through her actions, you know, we can. The prosecution is trying to show that this neglect was intentional and that this neglect resulted in the child's death. But, you know, I think a general intent issue here, as opposed to specific intent, is an effort to try to minimize the ideas of mitigation with regard to mental health issues and with regard to drug addiction.
And interestingly, in the defense's closing argument, they said, look, we're not fighting the child endangerment charge. You can find her guilty of that, but you can't find her guilty of murder because there's no malice. We're going to talk more about that. Let's take a quick break, and now we're officially on verdict watch in the Cheyanne Harris case. Let's take a break. Some administrative matters there in the Charles Merritt case. Let's break it down right now. Gene, this is a big issue. This is a big issue about this testimony coming in, this video reconstruction expert, because if they can place, the state can place Charles Merritt's truck outside the McStay family home right at the time that they disappeared, that's a huge win for them, right?
That could be the whole case, because it's just not a coincidence. That is right at the time when they were taken from the home, allegedly. I got a comment on the expert thing. if I had an expert that continued to, draft charts and everything after I produced charts to the other side, I would go ballistic. That's number one. Number two, if they don't give sufficient time to the defense to analyze these additional charts, that could be, Jesse, that's reversible error.
And that's a danger that we've seen in other trials before. Now, gentlemen, I want you to stand by. I'm signing off. Bob Bianchi's coming in, and he's going to guide you through the next chapter of this case. We'll be right back.
Well, good afternoon. My name is Bob Bianchi. I'm going to be taking it for the next couple of hours. It is always great to be hosting on the Law and Crime Network. I love being here. Thank you so much for those of you who watch our gavel-to-gavel coverage. And as you know, we got a lot of interesting stuff that's on the plate. Really interesting trials, some great lawyering. I've still got Gene and Matt that are with me. They're going to take me through the next couple of hours. Just so you know, as an update, in the McStay family murder case, there's some activity going on in the courtroom, and as soon as something important happens, our great producers are going to let us know. We're going to go right into that court. But as you also know, we've been covering the Cheyanne case. I mean, she is unbelievable. They did opening statements. They put all the evidence on. The prosecution, the defense did their closing arguments, and now we're going to be in that phase of jury deliberations. There you see she is there right now. She is accused of being responsible for the death of her 4-month-old baby boy Sterling. I was just saying to the folks at the Law and Crime Network before I came on, as a seasoned homicide prosecutor and as seasoned prosecutors and defense lawyers that I know my guests are, I think I speak for them to say it's almost difficult to cover this case. We have seen a lot of bad things in our careers, but there's something about this one that collectively we all think is just so sad, to think of that beautiful gift of God, 4 months old, for at least 9 to 13 days, dehydrated, not fed, maggot-infested diapers because it hasn't changed. The testimony of the first responders and police officers, also seasoned people who broke down on the witness stand as they talked about what it was like to respond to see little baby Sterling and ultimately his demise. It is absolutely a sickening and grotesque case. Well, what the defense is trying to do here is say, hey, this isn't a murder. There are extenuating circumstances. This case should be lower, something less than murder. And we're going to go through the little legal permutations of what the defense lawyer is trying to do. Gosh knows they've got a really, really, really tough job in their hand, because no jury is going to like to see that beautiful gift, as I said, that 4-month-old boy Sterling die in the manner in which Sterling died. Hey, listen, let's listen to some of the closing arguments that will give us some insight as to at least what the lawyers are trying to do with respect to convincing the jury of their respective positions. Prosecution, jury, give them the full boat. Get her for every single charge we filed. The defense, hey, let's be reasonable and do something less. Let's take a look.
Sterling. Every time she went in her bedroom to lay in her bed to sleep, every time she placed Nala in the playpen, Nala, who had a bed, who had blankets, who had toys, every time she placed Nala in that crib and didn't go take care of Sterling, didn't hold him, didn't change him, didn't feed him, that was an act. Every time she turned on that fan that's facing Nala's bed to keep her cool, but left him suffering in that back room, that was an act. Every time she turned on the ceiling fan in the living room to keep her family cool and comfortable. While Sterling was dehydrating, while his organs were shutting down in that hot back room, every time she did that, that was an act. Every time she took a step in this tiny apartment and went somewhere else besides Sterling's bedroom to take care of him, it was an act. Her bedroom, you could take 2 steps from her bedroom and get right into Sterling's room. Her bedroom had an adjoining wall. This is a small apartment. She heard him scream, and she did nothing. How many days did he cry? Wanting food, wanting hydration, wanting to be touched, wanting to be changed. Is that why the mattresses were propped up against the wall? To prevent some of that sound coming through? Is that why the door was always shut, so she didn't have to hear it as loud as it would be with the door open? How many times did she ignore those cries? Now, you know the cries stopped after a while because he was too ill. He was too frail. He didn't have the energy to cry anymore. But there was a time where Sterling cried and cried and cried, and nobody took care of him. And every time she ignored that, that was a choice for her. Now we have to look at were the acts intentional. Okay? Now this is not in the sense of were the acts intentional with any type of specific intent. Okay? Like I said, the result is bodily injury. We don't have to show that she intended physical harm to Sterling. We just have to show she knew what she was doing. That's the only thing that you get to use Dr. O'Hara's testimony for. That was she aware of her actions? Were her actions not an accident? That's the only thing that you're considering. So how do we know that they were intentional? Because she knew Sterling was not being cared for. She knew every time she walked by his room and didn't go in there was a time that he wasn't being fed, was a time that he wasn't being changed. Right, you knew from Zach Cohen's testimony he had nothing to do with Sterling. He didn't change diapers, he didn't go in that room, he didn't think Sterling was his, and he didn't care. Cheyanne was fully aware that she was the sole provider for Sterling, that she was the only person who could give Sterling the care that he needed, and she chose not to do it. She was aware that she was not doing that. She knew he needed help. Anyone who saw that child, who heard that child, who looked at that child during that time frame would know that he needed help. You wouldn't even have to see him to know he needed help. Everybody knows, I don't care what level your education is, everybody knows a baby needs to be fed. A baby needs hydration. A baby needs a diaper change. Right? She knew he needed her help, and she knew he was dying. Because again, that's just common sense. You don't feed your baby.
Okay, so there is part of the prosecution's closing statement, and you hear very specifically talking about the acts she didn't do. Now, this is a very specific legal term. The prosecution's trying to show that this was intentional. Gene Rossi and Matt, let me go to Gene first. Gene, I don't know if the prosecutor did it. I haven't heard the whole closing statement right now. She basically is saying every time she took an act, a step away, a step to do this, that, and the other thing, this baby was not fed. This baby was not changed, was not touched and held, was not cared for. I would be also adding to it, not that you have to do it the way I would do it, but I would say, you know what? It was no different than taking a gun and putting it to that kid's head and pulling the trigger. What are your thoughts?
I think that's a very good analogy. Only a gun takes about a millisecond to dislodge and go into somebody's brain.
Yeah.
This took several weeks. I got to say, what I like about the closing argument by the prosecution is an opening and closing should be bookends. They should be consistent. And her opening or the government's opening, the theme is very consistent with the closing. And that's the other thing I like. And she's asking questions, you know, how many days did the baby cry? You know, was she aware of her actions? She's asking the jury questions, and of course they're rhetorical. I did want to comment, Bob, I'm troubled that they're not giving a specific intent instruction for first-degree murder. I'm very troubled by that, but maybe that's the law in Iowa.
Yeah, and Matt, I want to just go to something that Gene said because I think it's important. Is as we know, a lot of lawyers watch this network and law students and true crime aficionados. And we're talking about the presentation. So the prosecutor has been very continuous, very specific. It's not loose. They're very focused in driving the same themes over and over again. Now, we all know as lawyers when we're in that courtroom when we're prosecuting a case like this, if it's something short of a murder conviction, the prosecution sees that as a loss. They want to show that this is very intentional, purposeful conduct, if you will. Each state has different words that they use, and that this wasn't just some sort of act of negligence or recklessness. They really want to be able to prove the top charge here. I think the prosecution's done a very good job, as Gene has. What have been your thoughts?
Oh, I do too. I think that the prosecution is being very methodical, laying out, what they believe are the important aspects of the testimony that's been presented to the jury. I mean, I think what they have to prove here in terms of first-degree murder is an extreme indifference, to human life. So they're laying out that, hey, you don't have to be an educated person to know that a child needs to be fed, that a child needs hydration, that a child needs to be held. And while you're sitting in that house and in that apartment and doing a whole lot of other things, you're not doing those very basic things, meeting the very basic needs of the child. And
Gene's point on that one, in addition to saying it's just like putting a gun and pulling the trigger, that would have actually perhaps been more merciful to 4-month-old Sterling, given the amount of time it took for his life to ebb away. Let's listen to a little bit more of the prosecution, who we all agree is doing a great job, more of their closing statement.
Back room. They could afford drugs, right? They had plenty of money for that. They earned $45,000 a year. Their rent was $330 a month. Sure, they had debts. Don't we all? That doesn't excuse not providing for him. And there's no evidence to show that she could not reasonably provide for his care. She knew how to care for a child. Nala was living proof of that. She raised Nala from an infant. She had her when she was a baby. She changed her diapers. She gave her bottles. And you heard during the interview how much she talked about Nala and all the things that she did with her as a baby. But she knew how to care for a child. In her interview with Callaway, she described where the formula and the baby food were kept. She knew that. She described how much formula was in the can. She knew how much formula was in that can. She described how she mixed the formula. She described how Sterling would get louder when she wanted food. So she admitted she could hear him. She knew what he wanted when he cried. She was reasonably able to care for him. She described how she changed Nala's diaper the morning of August 30th. In her interview, she talked about how she had gotten up and changed Nala's diaper and put on a movie for her. She knows how to change diapers. Reasonably able to provide. She said that she knew when Sterling was uncomfortable because he would fuss. And then she said that's pretty much all he could do. So she fully recognized the fact that he was wholly dependent on her. And she was reasonably able to provide. Elements 5 and 6 in this, in the child endangerment, it's the same discussion that we had for causing the death in count 1. This was homicide, death at the hands of another, denial of critical care. It was death at the hands of his own mother. Elements 5 and 6, proven beyond a reasonable doubt. Death occurred, substantial physical harm.
A powerful prosecution closing statement in this case. I think it's going very well for the prosecution here. I'm online with our chatters in the Law&Crime Network, many of whom are as disgusted as I and my guests are about this kind of case. Guys, we're going to take a break, but we got a lot going on. Remember, in the McStay family murder case, they're getting ready to go back to court, and when something important happens there, we'll be there. And if not, next we're going to hear the defense closing statement in the Harris case. Man, oh man, how do you go about making that closing statement? We'll be right back. All right, so the QuickBook representative is on under multiple direct and cross-examinations, and then Gene Rossi, the court decided to ask some questions, clarifying questions, which I actually thought one or two of those questions were pretty good. I'll get to that with you in a minute. But, of course, that opens the door again for the judge to say to the lawyers, do you have any questions after my questions, which in this witness you were assured they were going to ask more questions. But what he's bringing up here, Gene, am I getting this right, is that he's basically saying that there's emails what prompts these screens, and on the 8th, this conversation occurs, and on the 9th, when he went to put in what should have populated the same email address, it did not populate the screen. Am I hearing that right?
I think you and I are hearing the same thing. I got to tell you, my mind is exploding. This is an example of a witness that should have been 10 minutes, and it's going to take about 2 hours. And it's really sad. But I agree with you. The judge had good questions. But I think that's the punchline that you just talked about.
Yeah, it seems as if he's indicating that before they can delete the accounts, they have to email the person back on a number of emails in order to delete them, and then that they search these accounts by the use of email. That's what QuickBooks does, and that's what the judge was clarifying. You know, what's a little, and again, it's frustrating to me as a lawyer because I would have liked to see the defense lawyer make the arguments they were making without the constant interruption, so it became difficult to follow where they were going, but he's clearly going somewhere. There was something important about this testimony that the defense and prosecutors did so many kinds of examinations. There's something key that went on here, in my opinion, Gene. The sad thing is I'm not really sure what it is.
I'm guessing. I am guessing here. But because they asked so many questions on cross and recross and recross, I think what they're saying is, okay, Merritt's cell phone does connect him or his phone to QuickBooks, but there's a lot of other movements, a lot of other moving objects that suggest that it is not Merritt and it could be Dan Kavanaugh, who apparently may have had the opportunity to have access to these accounts. That's the key. Did Kavanaugh have the opportunity to access those accounts? That's what they're trying to do, the more I think about it.
Gene, well, I think I'm bringing you along a little bit of my path here, because let's not forget that on the family computer, there was searches that were going for Mexico and how do you get your kids' passports to go to Mexico, when presumably that was when they all thought that it was a missing persons case and or that the family went to Mexico, which the state is now saying did not occur. So did somebody have access to the family home computer? We don't know, Gene. I mean, maybe there's an argument here by the defense that this was a plan, a plot, to have this finger point at this person. It wouldn't be the first case where something like that's happened. This is why this case is a nail-biter of a case. Gene Rossi, great having you on. We're going to go to a real quick break, and I'll be back on with more of the gavel-to-gavel coverage on the McStay family murder case. Okay, I'm glad our producers pulled that clip out right in the opportunity of the testimony of listening to Mr. Baker himself today. Gene, I guess the argument is going, if I'm getting it right from the opening statement, is that the defense is saying that Joseph McStay wanted him to get rid of the online account, be able to put it onto a desktop, and then after this is done, they have a call with one another to say the job has been accomplished, and he indicates to the defense lawyer that the reason people would do something like this is because they don't want the online account available to everybody in the world who may have his password, but to keep it more secure on a private computer. Keeping in mind throughout all of this, the defense's argument is that there's a big beef between Joseph McStay and Dan Kavanaugh. I think this is where they're trying to go with all of this. And he did it. We're not arguing. He did it because of the other problem with Kavanaugh.
Mm-hmm. Yes, absolutely. And what I heard from the opening, and that was pretty good opening. I don't know if it's accurate, but it was a good opening. It sounded like it. It's that Joe and Chase were copacetically together. They were working hand in glove, and there was no deception. there was no attempt to conceal anything, and that any problems were with this other guy. What I would like to know is why did Chase Merritt, after they obviously had been killed, were there calls or communications made on February 8th and 9th? I still don't know the reason for that one. But there was something that he said in his opening, I hope I got it right, is that there was a call after the car was allegedly seen in that video surveillance. Yes. I think that's what he said.
After the phone call, so I guess trying to argue, and again, we're trying to put pieces together, but it came off to me, if I were a juror sitting there, that he's doing what Joseph McStay wants him to do. Yeah. He's calling him to tell them that mission is accomplished, and like right after these phone records show that he was on with QuickBooks. And at that time, minutes later, this van is leaving the location, which they believe at the time the bad guy or the bad people or the people that took the family or the family went on their own, whatever the case may be. But that was not Chase Merritt that was driving that van. There's a number of interesting pieces that they're bringing out there. And again, like you said, Gene, if they don't have to prove it because they're the defense, but it certainly throws a monkey wrench and explains why the prosecutor was jumping out of their seats like a jack in the box, trying to limit the cross-examination of this witness.
Well, Bob, this is taking prosecution and trial work to another level. When you object as much as the prosecutor did, and I think half, if not more, of her objections were baseless, argumentative. Yeah. You are telling the jury that this is a really important witness and that the cross-examination is really hitting pay dirt. Right. And you seem defensive and weak. Right. I didn't object a lot during cross-examination of my witnesses because I had confidence in them. Yes. And when the burden is on the state to prove its case beyond a reasonable doubt, you better go in there with pristine witnesses or be ready to take the hits you need to take rather than have the jury think that you made a mistake, even if you didn't, Gene, even if the violations of the evidence rules was correct. Objecting so much makes the jury think you're getting hurt and trying to hide something, and that never is good for the prosecution. Hey, but let's put this now. This is great. We listened to the testimony. We listened to the defense's opening about that testimony and got a lot of great information. But because this has been so battled by these two sides, let's go back to the direct examination of Mr. Baker from QuickBooks and see if we could now glean out even a little bit more, because this is, while it was a tedious witness, an important one.
Now, on February 9th of 2010, at approximately 8:06 a.m. Pacific time, did you receive a customer support call for Joseph McStay? Yes, ma'am. Okay. Now, given that you can't see, prior to losing your eyesight, did you have an opportunity to review the information that you had noted from this call? Yes, ma'am. Did you participate in a conference call with a Detective Dan Hankey back in 2014? Yes, ma'am. And at that time, when you reviewed the notes with him, did you notice any errors in any of the notes? No, ma'am. Did you also have an opportunity to review the emails on the account that you had sent? Yes, ma'am. And were there any errors or anything incorrect about the information that Detective Hankey went through with you? So what information, with respect to that call that came in on February 9th, what information did you gather from the caller? The caller actually gave me the name of Joseph McStay. When I asked them for their name, they gave me the name of Joseph McStay. They gave me the telephone number and the name of the business, as well as the email address. And as you sit here today, do you recall what that particular telephone number was? No, ma'am, I do not. The telephone number now exists with another customer service representative. If they had provided the email of Joseph McStay 69 at hotmail.com, can you tell us if that was the same account? It was not. It was not the master administrator email. It was not the same account for that. So it would be listed as a separate, a custom user business owner wants to hide information. Is QuickBooks password protected?
Yes, ma'am.
Can the password be changed?
Yes, ma'am.
And would you have to be the master administrator to change the password?
You would have to either be the master administrator or that user where you could receive the password change email.
Okay. Now, you indicated that once that information is purged, you can no longer retrieve it from QuickBooks. If the caller had asked you and informed you that they wanted to retain data, would you have put that in your notes?
Yes, I would.
Now, if a caller calls you and requests to delete the entire account, does that happen automatically when they call you?
No, that's not something we will do. It has to actually be the master administrator, and there are information that they have to provide for us. I would have sent them an email with specific.
Well, guys, like I said, this was a tedious witness in the manner in which it was presented, but a very, very important one, especially considering that financial motive is the biggest thing the prosecution's got on its side with regard to the person they have sitting in the chair, Charles Merritt. We're going to have to take a quick break. We'll be back on the other end with more of this fascinating case. Okay, so, Gene, for the first time that I have seen so far in this trial, after a witness testified, usually this is done while the witness is testifying, the judge has been very, very tight in not letting the defense lawyer make the record that we have so often talked about as crucial for purposes of appeal. But with respect to this witness and outside the presence of the jury, the defense attorneys made a number of arguments. I want to go to the one, just so our audience understands, especially our aficionados out there, that he makes a reference to Rule 402. Generally speaking, that is what we call a relevancy rule, saying that some piece of evidence either wasn't relevant or should have been decided to be inadmissible. And he's also citing a confrontation rule, as I see it, where he's saying that you allowed this witness to kind of opine or offer an opinion that there was something suspicious or not right about that, and we weren't given an opportunity to cross-examine and or to rebut that. And the judge kind of indicated, well, it's really not germane to the case, which is where he brought the 402 rule out, which is that it needs to be relevant evidence and nevertheless was prejudicial because they weren't able to cross him on that. Is that how you heard that in your thoughts? Because I know that's a little nuanced.
Yes, and I'm going to really come down hard on this judge. I tell you, that crystal ball you talked about, he is making some outrageous rulings. This one is appealable, and it could come it'd be reversible error. Here's why, Bob. From what I understand, they allowed this guy, Mr. Ryan Baker, to give hypotheticals as to why and what is the mens rea of someone who makes a phone call to get stuff deleted. I suspect he wanted to hide something, blah, blah. Mm-hmm. And then on cross, as I understand it, they wanted to get into, well, why do you give that speculative answer? What's your basis for that? And the judge shut him down? Yeah. Are you kidding me?
Gene, that was where we were talking before. Just intuitively as lawyers, we knew that these objections as to argumentative and facts not in evidence made no sense to us as far as what we allow cross-examination for defense lawyers to look like. But then when our producers were smart enough to be able to get the opening statement of the defense attorney, which you can forget in a very long trial, and you see the critical nature of what the defense is saying here, then it made the ruling of the court denying the aggressive cross-examination in this area bad. But to add insult to injury, and I agree with what you're saying, is that he allowed this witness to testify as an expert, if you will, that this could only be done really for a nefarious reason, when the defense's explanation in the opening was it was done at Joseph McStay's request so that their records were no longer online but rather just on a computer because he was worried about that for some reason. Defense argument is that reason is Dan Kavanaugh, which you, Judge, limited us bringing evidence as to third-party guilt to Mr. Kavanaugh. This is becoming a cascading set of reversible error in my mind.
Bob, it goes back to what we've been talking about for weeks. Pigs get fat, hogs get slaughtered. You had that instance of the 404B where they allowed 5 instances. You stopped at 2. You know, these prosecutors are pushing the edges of the envelope. And it's you know, I really see them going down a bad path here of reversible error.
Okay, Gene, I agree. Hey, I'm going to ask for our guys who are in the chat room, which you can always get into, lawandcrime.com. I love their analysis and their questions. But I'm throwing a question out there right now while we're going to go to a break. And I want to know, do you guys feel that at a certain point in time, the defense is being limited by this court in its rulings vis-a-vis Dan Kavanaugh, as well as properly cross-examining witnesses like Mr. Baker? I don't know. I'd love to see your opinion. We'll be right back. All right, welcome back. As you know, we've been covering the McStay family murder case. It got really hot and interesting today with the kind of witness you wouldn't expect, a financial kind of person, a QuickBooks guy. Gene Rossi, I know you got to go. It's always a pleasure being with you, my friend. We'll be on soon again, but we're going to go to break real quick and have another great interview real soon.